before you shout, this property is our property, this land is our land, make sure your name is in that document. Guys, watch this.
It is not enough for you to come as a man and brag that my wife did not contribute. She contributed though, emotionally, support and otherwise. There are times when you were carrying out that building project, she was feeding the home. There are times you would have given her 20,000 because my wife, I'm carrying out a building project to just manage this 20,000. Oga, you know they rich. The woman has her own money. So those are factors the court puts into consideration. So it is not enough whether she brought finance or not. So far as that property was gotten during the pendency of the marriage, the law will presume that she contributed to that property, and so the property must be shared between the parties.
I also made a video aligning to the position that this lady just made. Watch my video as well.
The properties of a man with his wife, when in fact the wife did not contribute anything, the answer is yes. Contribution in the eyes of the court or in the eyes of law is not just about money. If it can be shown that the woman gave birth to maybe a child or children, maintained the family, took care of the family while the man was out there looking for maybe jobs and maybe eventually got money to build those properties, that woman's commitments can be seen as contribution.
This is also my video, and this position of the law has been in existence up until now. Guys, this is actually the position of the law as at 2024, not 2025. Do you know why I say it's actually the position of the law as at 2024? It's because sharing of property, matrimonial properties, are discretionary. It means the court leaves it at the discretion of the judge. That's the law. The judge look at the circumstances of the case and share the property. Now, this does not relate to 50-50. There is nothing like 50-50 except you guys have a clear evidence that this property is actually a joint property. However, the recent position of the law based on the Supreme Court case in Nigeria in Ogolu versus Ogolu in 2025 is different totally. And because it's the Supreme Court, that is the current position that we must follow. The position of that case is that marriage does not automatically confer co-ownership of property. No matter the type of marriage, it does not confer co-ownership of property. The second is that the property belongs to the person on whose name is in the title document and is registered under, unless there is a clear evidence of joint intention or contribution. If, for instance, the property's name is registered as Okon, it belongs to Okon and it has nothing to do with Okon's wife. The court also held that mere marriage does not confer proof of ownership of property. Mind you, the Constitution empowers every citizen to own property individually, irrespective of your marital status. The Constitution gives you the right to own property on your own. So before you shout, this property is our property, this land is our land, make sure your name is in that document. Ladies, if your name is not in that property, and you don't have clear evidence of contribution, clear evidence, monetary and financial evidence of contribution, then that property does not belong to you. So my advice to my fellow ladies is go get a job, buy properties for yourself, buy properties in your name, and stop depending on your husband's property. If he did not include you in the deed of assignment or conveyance or any title document respect to that property, just know that that property is his own. And if you really brought money or you contributed in that property, then make sure your name appears on that title document and not Mr. and Mrs. Your name and his name, nothing like Mr. and Mrs. in law. I hope this helps. Take care.